You're listening to Compliance Conversations, your inside scoop on all things healthcare compliance, auditing, and coding. Now, let's get on with the show.
Welcome, everybody, to another episode of Compliance Conversations. I am CJ Wolf with Healthicity, and today's guest is Christina Kuta. Welcome, Christina.
Great. Thanks for having me.
Absolutely. Thank you so much for making the time to talk to us for a little while. And Christina, before we jump into our topic, we'd love to hear a little bit about yourself, what you do, and a little bit of your background, anything you're willing and comfortable sharing.
Sure. So I'm Christina. I'm a shareholder with the law firm of Roetzel Andress, and I concentrate my practice predominantly in the regulatory and transactional healthcare space. So a lot of work with buying and selling healthcare practices and a lot of work with compliance and the regulatory component of healthcare practices and healthcare providers. I'm based in Chicago. My firm has offices in many other states. And I've always been since I was a kid, always very interested in healthcare issues, healthcare laws. For a long time, I was going to be a doctor, and then I took biochemistry in college. And I realized that was not going to be my forte. So I quickly switched paths to be able to still be in the healthcare industry and still work with healthcare providers, but didn't have to do chemistry or a lot of math, which seemed to suit me a lot better.
Awesome. Well, thank you so much. We're glad that you are where you are and doing what you do, because that does affect patient care ultimately, right? When people are burdened with compliance issues, they can't focus on taking care of patients. And so trying to set things up the right way is an important mission.
Absolutely. And I don't know if your audience would agree with this, but I see the last few years things have gotten a lot more comprehensive with respect to compliance, see a lot more compliance issues and a lot more time practices are having to spend on compliance issues, burden for any healthcare system or provider, particularly for your small providers, your solo providers, your small groups, your small healthcare businesses. It's a lot of burden and a lot of effort. So to the extent, you and I can help ease that for people, love to.
Yeah. Well, and I don't know if you know much about me, but I come from a clinical background. I did go to medical school, and I ended up getting into compliance and administration, and always felt like any burden I can remove from the physician lets them, focus their cognitive load on something that's much more important. Now, of course, there are some things that only the clinician can do. And so as compliance officers and auditors and attorneys, we all know that educating folks that are on the front lines is important too. And so we're going to talk today about what to do if audited. Our audience, we have a lot of auditors in the audience and a lot of compliance officers. And so we're going to kind of walk through that with an expert like Christina, who helps clients out on these types of things. So let's maybe just kind of set the foundation here and say, I'm a hospital, I'm a doctor of practice, I'm whatever, and I received some notice of a third-party audit. So I get that notice. I'm like, oh, great, this is going to make my week or my day just the best. So what are the first steps you recommend people take when they first get that notice?
Sure. As cliche as it sounds, don't panic. That is the first thing. I have had people call me say, I'm going to jail. And I'm like, I have been doing this job for almost 20 years. No one I know has gone to jail because they received a compliant audit. So jail's not going to happen.
Right.
And, we'll get through it. Like, it is a burden. It's a pain. You don't want to see it. It's scary. A lot of times people worry, if I get this audit, is 7 audits going to follow this audit, right? Or is it one and done? All valid questions, but you'll get through it for sure. After you take your breath and you panic a little, because I'll tell you not to panic, but everybody's going to panic for a minute, review the audit carefully. So a lot of times people don't review it carefully. They review it fast. They see CMS or a MAC, a Medicare contractor name, and they don't really pay attention to what the audit's about. And there can be many different reasons for an audit. It can be just a general compliance audit. There's things we call UPIC audits. There's audits that could be triggered because somebody made a complaint. So a lot of different reasons. And in reading why you receive the audit or what the audit says, you often can pick up some clues on why you're receiving that audit. You want to also pay very good attention to deadlines. So the audit will tell you, we want these records, in this time frame. Often it'll actually give the names of the patients and the specific dates of service, and it'll give you a deadline. We want it by this day. I've worked with a lot of different people that didn't pay attention to the date and called me and said, "Oh, I've got to respond to this audit." And I look at the paper and I'm like, "You had to respond to this audit 3 weeks
Right.
ago." I have found that third parties requesting audits, government or commercial payers, and we'll talk a little bit about the distinctions there today, but uh, they're generally very flexible with time. If you tell them, "I need more time, this is burdensome," there are some practices that are still very paper-based. And if you have to
Right.
respond to an audit paper-based, takes a lot longer than just going into an EMR and clicking a few buttons, right? You have to
Right.
copy, we never recommend you give original records to anybody because they say they'll give them back to you, but you can't guarantee it. So
Right.
it might take time. Get ahead of it. If the audit says we want these in 30 days and you think there's just absolutely no way, call the auditor. If you're going to work with an attorney, have them call the auditor, ask for time, figure out the timeline, docket the timeline, put it in 3 different calendars, make sure an administrator in your office has it or your billing folks. Because if you are a busy clinician, which most clinicians are, it's easy to forget about these kinds of things, especially since it's not routine. It's not like, "Oh, I know
Yeah.
every Friday at 2 o'clock, I have this meeting," right?
Right.
This is out of your ordinary, and easy to forget. And I find that particularly the government is less forgiving if you blow the deadline. So you want to always make sure to get ahead of the issues for sure. Um, Another thing I always tell people is try to consult knowledgeable legal counsel. And that doesn't mean the lawyer who does your taxes or the lawyer
Right.
who does your real estate, right?
Right.
Great lawyers, I'm sure, know about buying and selling a house, know about how to get good tax benefit for you, but don't have experience in healthcare. And I spend a good part of my month sometimes having to clean up mistakes or issues that other lawyers did, not because they're not good lawyers, they just didn't know. They waded into an area they thought they
Right.
understood, but didn't understand. And because of that, mistakes were made that now we have to try to unwind. And again, with the government particularly, you never want to be behind the 8 ball, as they say. You want to sort of stay ahead of everything and not have to ask for forgiveness. What's that old adage? Do it now and just ask for forgiveness later.
Right.
Great
Right.
idea when you're a kid wanting to do something your parents don't want you to do. Not a great idea with the government when it comes
That's
to
right.
healthcare payments. Um, and the other issue, the immediate, is only inform people that need to know. So tell your lawyer, maybe your billing folks need to be involved to help pull records. Obviously, if you have an office manager, an office administrator, he or she may need to know. But don't sit in the front office and be like, "Oh, we got this Medicare audit. Now I've got to give Medicare records." And there's a few reasons for that. I think, one is you don't want patients to hear because patients don't know what that is. They don't know it's
Right.
routine. And they think, why is my doctor defrauding Medicare? That's the first thing
Right.
they think, right? And 99% of the time that's not true, but that's
Right.
what they think. The other issue is you don't want to panic in your employees. Sometimes employees get a little jittery. They may not understand as well, and they think, "Oh no, we're getting audited by Medicare. We're a practice that has a lot of, older patients. We have a lot of Medicare patients. What if we get in trouble? Are the doors going to close? Am I going to lose my
Right.
job? Did I do something wrong?" Like if,
Right.
and they're going to find out about it now and I'm going to get in trouble. So most folks don't need to know about the audit. So keep
Right.
it to an absolute need to know basis.
Right.
I think that's really important to prevent panic, to prevent people making assumptions. And also, this has happened a couple times in my experience where you have a disgruntled employee who hears about it and they think, "Well, now's my chance." And they
Yes.
call Medicare and say, "Oh, I heard you're auditing." Well, just so you know, they're
Yep.
also doing X, Y, and Z, right?
Right.
And sometimes you can't prevent that, but you certainly want to minimize it from happening. You don't want to give people
Exactly.
a sort of a reason to think that you have done something wrong and that's their opening.
Yeah. Well, great advice. So take a breath, don't panic, but be serious about it. Read the details of the letter. They usually, in my experience too, the letters are pretty detailed. It'll say what they want, when they want it. I love the fact that you said, if there is a need for maybe a little bit more time, maybe reach out to the requester. And I'll give you a good example. Sometimes, like if you're a lab or if you're a physician who relies on referrals, sometimes the medical necessity documentation is in the ordering physician's chart. You might not have it. You might need to get, additional information, and you don't mind requesting it, but you also don't run that other clinic's life. You run your own EMR. You might be able to push a few buttons and get that, but there may be some other documentation you need to get, and you're relying on people outside of your control.
Absolutely. And I'm so glad, this is a little bit of a sub comment, but I'm so glad you mentioned like labs or third-party vendors that rely on the medical necessity of other physicians, like even like independent diagnostic testing facilities.
Right.
A lot of times those providers get audits. And every single time that I've worked with one of those providers who's gotten that audit, they've told me, well, I don't control medical necessity, so why do I care? You care, because Medicare will only pay for that lab or that x-ray if it's medically necessary.
That's
And
right.
it really is your job to show that there is medical necessity, meaning
Right.
you have to get those physician records or
Yeah.
the other provider that ordered the service. And if it doesn't show medical necessity, even though you don't control it, you don't get paid for the service.
That's right.
So
They're
yeah,
gonna follow the money. So they're gonna go who got paid. And that's where we can get our recourse. So really good input. So you had mentioned just a few minutes ago kind of differences between government payers and commercial payers. Any thoughts on that? Any considerations for our listeners?
Yeah. So to the extent of how you respond, they're pretty similar. Again, don't panic, read it, make sure you respond on time, get extra time if you need it. All that stuff still applies. The differences are the potential outcomes. With commercial payers, generally, there's not a law that you may have violated. So there are laws related to commercial payers, and certainly you have a payer agreement that you have signed or you're subject to as a participating provider. And because of that, there's rules you have to follow. So you have to respond to the audit and go through the audit process. But at the end of the day, there's no federal statute like there is with maybe Medicare or Medicaid that governs you submitting that bill. So less of a potential penalty. Generally, I find commercial audits are much more relaxed. They're not as formulaic or procedural. But the one thing with a commercial payer is when you're dealing with a Medicare audit or Medicaid or anything, federal-based payer like TRICARE, the military insurance, it's governed by very specific laws and rules, and they all work the same because the contractors who work for those entities have a specific set of rules they have to follow. The commercial payers, that's not the case. The commercial payers, there may be state laws on how far back they can go for audit or how far they can go back to recoup, but the process of the audit, appeals rights, things like that, and we'll talk about appeals in a bit too, can vary from payer to payer. So you need to make sure that, like, if you get an audit from Blue Cross and then you are unlucky enough a month later to get an audit from Cigna, let's say, you can't rely on the process that you used and went through to start and finish the Blue Cross audit with the Cigna audit. It could look very different. In many ways, they're similar, but it can look different. So that is something to make sure. If you get a commercial audit, know what your provider agreement says. And there's the provider handbook that nobody reads until they have to. You need to dig that out and find it and look through it and see what it actually says about auditing, the payer's rights, appeal process, etc.
Great advice. We're going to take a quick break, everybody, before we ask some more important questions here. So stay tuned. We'll be right back.
Compliance is complex, which is why you should visit Healthicity's Resource Center. It features updates on the OIG's new General Compliance Program guidance, CEU webinars, and more. Visit healthicity.com/resources today.
Welcome back from the break, everybody. We are talking to Christina about what to do if audited, and we've been having some really good conversations. And now I want to ask a little bit of, should we be doing some of our own exercises beforehand? Meaning, should we be doing some self audits once in a while, right? And are providers required to conduct self audits once a third party audit is received? How does that work? Because a lot of us in compliance, we may already be doing some proactive auditing, but then we get this audit request out of the blue. Now we're required to do more and this and that. What are your thoughts on that kind of scenario?
Sure. So I always recommend that providers are conducting self audits routinely, whether that's once a year, and depending on the size of your organization and the type of services you provide, that might make sense. For other providers, it might make sense to do it more frequently, quarterly. I have a couple providers I work with that do it monthly. But self audits should be conducted because you want to find problems with billing or claim submission or even compliance issues before they occur. Super important. And it also goes a long way, with the government. If you find a problem, you let them know of the problem, you resolve the problem, then them coming to you and finding their problem. And you never want them to come to you and find out you knew about the problem and did nothing.
Right.
That's the biggest of the issues. So you don't want that to happen. So very important. There also is the potential that you may have a legal requirement. So there is a law, and I blanking on what that law is, but I promise you it's out there. And it says that essentially, you, like for Medicare, you have a requirement, if you are on notice there's a problem, to self-audit and self-report issues that you find. Okay.
Right.
And there's some time frames for how you can do that. And there's different mechanisms to sort of self-report if you find a problem. But if you get an audit, let's say from Medicare, for example, and that audit is conducted and the auditor comes back and says, we think there's these problems, you are now on notice that there's potentially those problems. And you do have a requirement, a legal requirement, to go back and look, and the look back period for this purpose is generally 6 years, to sort of look at those claims and issues and determine, is there a systemic problem here? Was there a problem? Were there issues? And if so, self-report that and refund amounts that you were overpaid. And a definition of overpayment is essentially any money you weren't entitled to for some reason. And again, if the overpayment was things like just an error, we thought it was the CPT code should have ended in 1.5, it ended in one, it should have ended in 1.4. That's a clerical error. Maybe worked with a client once that had a computer glitch. They were putting in the codes, and for some reason, this computer program for 18 months was changing all their 1.4 CPTs ending in 1.4 to 1.5. So what was happening is they were upcoding and not even realizing they were upcoding. They weren't self-auditing. Had they self-audited, they would have been able to catch that before the auditor caught it. But then there's other situations, like I've worked with practices where they realize that they maybe billed for services. Very common is, they billed for services when they thought a doctor was Medicare enrolled and they weren't Medicare enrolled.
Right.
So it turned out that there was no ability for this doctor to be able to be paid. Those are some circumstances which may be considered more under a fraud category, even though it wasn't purposeful. And maybe you have to self-disclose that in a little bit of a different way than just returning money to the MAC, to the Medicare contractor. So, the long answer to your question, that was a long answer, but the short answer is yes, there may be reasons you have to self-audit and self-disclose. And if you get into those situations, you absolutely want to have knowledgeable legal counsel working with you, because the audit process is very detailed. There's things you have to do, specific timelines you have to meet, and you want to make sure you do it properly and disclose the proper information. If you don't, you could be subject to penalties. And also, if you don't do it properly, it doesn't close the matter. If you do it properly, it closes the issue, and you have sort of the understanding that the government's not going to come back for you with these particular issues. If you don't do it properly, you don't have that certainty. And, at any time during its statute of limitations period, it could come back and reopen the issues, which you never want to happen.
Yeah, such great points. So you've kind of been talking about some of these important considerations when conducting the self-audit. Anything else that kind of falls in that category of any other important considerations related to conducting the self-audit?
Yeah. So there's two main that when I work with all my clients, we talk about. One is you have to make sure that you're using a third-party independent auditor. People will say, I have the best biller in the world, and I'm not going to deny you may have the best biller in the world. The problem is your biller is the one making a lot of these billing decisions and educating you on billing issues. and billing concerns. If they made a mistake, they probably don't know they're making a mistake.
Right.
They're not going to likely find their own mistake. In the example I gave you of where the computer was upcoding randomly, they might find that, but they may think that you can bill a certain code or a certain service is covered when it's not, or it's not covered in the way this particular provider is providing the service. And they just don't know that. And that's why you want an independent third party. You want someone else, and there's a lot of auditing companies. Every state have them. There's national companies that can provide auditors. And it's also good to look for a third-party auditor that has some specialty or folks that have expertise in your particular billing area. Billing is so specific to the type of service that you do. Compliance is specific to the type of service and the rules that apply to you. You want them familiar with that. You don't want just someone who says, oh, I've been the biller for chiropractors my whole life, and I'm a certified coder, and excellent at what they do, but they're billing, orthopedic surgery claims. Very different type of service. The other main issue is always, if you can, have the auditor engage through legal counsel. And the reason for that is it maintains, for the most part, attorney-client privilege of what you find in that audit. So a lot of times we tell people when you get audited by a third party and they come back and say you did 10 things wrong, get a third-party audit to look and see if they agree. Yeah, you did 10 things wrong. Or they may say, no, you did 5 things wrong and we think they're wrong on these other 5. We'll help you appeal. You want to make sure that you have legal counsel be the one to engage the auditor. And the reason is, if it turns out that the auditor says, you know what, you did all 10 things wrong, and you did 2 other things wrong that the government didn't catch, you can keep that as privilege. It can't be subpoenaed or something that the government can require you to turn over. Now, the auditor may come back and say, you didn't do anything wrong. We don't know what the government's talking about. Great, then you could voluntarily turn that audit over if you want. But keeping the privilege in case it comes back poorly for you is important. And a lot of folks don't know that. They don't know that that's even an option. But it's very important. I think that's also where having legal counsel that understands healthcare in general and healthcare compliance is really important.
Yeah, those are all great considerations from when you're doing these self audits. So, we kind of started our conversation with third-party audits. Let's maybe kind of get close to wrapping up here with this last question of what are some potential outcomes of third-party audits? Like, what could happen? I'm sure there's a lot of different variations.
Sure. So, absolute best case scenario is you get an audit, and the auditor comes back and says, everything looks great. In my almost 20 years, that's only happened one time. And I couldn't believe it. I actually had an associate of mine read the email too, just to make sure I was reading it correctly, because I thought this has never happened. And it probably isn't going to happen again. So, the next best outcome is they come back and say, hey, there's a few errors. We want some recoupment. We want some refund. And it's a small amount. And to be honest with you, practically speaking, if it's a low recoupment amount, appealing is expensive. If you get lawyers involved, if you have to get if you do your own audit, go through the appeal process, it can be costly. So if you're looking at a small refund amount, just doing a cost benefit analysis, which I always like to tell my providers to do, because we live in the real world. I like to fight everything because I think it's unjust, right? And my clients want to too. And I'll say, hey, they're asking for $10,000 back, but it's going to cost you $20,000 to win the appeal. It's not worth it, especially if you're a smaller practice or a smaller type healthcare entity. It just doesn't have the money to blow on principal. Principals are expensive, right? So that's sort of the next best scenario. And a lot of people will say, well, if I pay it, I'm admitting I did wrong. You're not admitting you did wrong. It's you're refunding. It's not something that's going to come back and bite you. It's not something they can use in a court. They're going to use in a court against you. Doesn't mean you're going to get another audit. In all my experience, I've never had anybody get one audit and then quickly follow with another audit. So that rolling audit concern doesn't seem to happen. You may get a significant error report or a large recoupment. At that point, people generally will consider appealing, because they'll say, well, this is a lot of money, or we really don't think this is right. So the appeals process varies. For commercial, a lot of times it's arbitration process,
Okay.
where it says in the provider manual or your provider agreement, you go through arbitration, arbitrator decides the response. I will tell you, commercial payors are generally very willing to settle issues. So if they come back and say, we think you were overpaid by $100,000, usually if you have a pretty knowledgeable lawyer, you can get them to significantly reduce the amount they'll take to settle the issue without even going to arbitration. That
Gotcha.
tends to be the case. It's not the rule, but it's
Right.
what we see often.
Okay.
The government doesn't really do that, so you have to go through the appeal process. Typically, there's 3, sometimes only 2, but typically 3 appeals processes you go through. The important thing to keep in mind with that is interest accrues the entire time. And right now, I think the interest rate's like 11.75 or something for the government. Don't quote me, but it's high,
It's high.
definitely over 10, right? So if you have a large recoupment and you want to appeal it, you're going to accrue interest that entire time. So if you lose at the end of the day, you pay what they say you owe back, plus you pay
Plus
interest. So
interest.
you've got to kind of make that consideration as well. The appeal process also can take time. If you go through all layers, you're talking a year or more potentially,
Right. Right.
depending on the backlog and when you file. You have timeframes to file. If you wait till the longer end of the time frame to file, it can stretch it out further. Another thing to keep in mind, again, you should work with someone who knows about the appeal process, is depending on when you appeal, if you file your appeal within certain deadlines, the government can't self-help its money, meaning it can't take what it believes it can recoup, it's entitled to, from current Medicare billings. But if you
Right.
don't file within certain periods of time, even though you still have time to file the appeal, if you don't file it towards the early end, the government can start self-helping, meaning it's
Correct.
taking money away from you, but you're still in appeal. Now, theoretically, if you win your appeal, you get that money back.
Right.
I say theoretically because I've not had anyone go through that process and actually win their appeal at the end of the day.
Right.
But that's supposedly what happens. But the government doesn't give you interest on that money that it took.
That's
So if
right.
if it self-helped $50,000 and a year and a half later you win, hey, here's your $50,000 back. But if you owe them $50,000 and a year and a half later you lose, you're going to pay $50,000 plus that very high
Interest.
interest rate. So
Yes.
doesn't
Wow.
necessarily work out in your favor. But typically people tend to appeal based on a cost benefit analysis. And
Sure.
I get it from a business decision, but it's tough from my position as a healthcare attorney when I see like, I think we could fight it. I think you
Right.
really have a good case here. And I want the government to know that they're not doing this properly and someone should
Right.
show them that. But the client's like, but I got to think about dollars and cents. And I get that because at the end of the
Right.
day, it's a business and it has to survive as a business.
Right. Yeah. So interesting. All these options. It does really convince me, and I hope it convinces our listeners to get somebody that's qualified and knowledgeable, somebody like yourself, Christina. Really appreciate you spending some time with us today. Any last minute thoughts or parting thoughts before we wrap up?
Yeah, just understand that everybody, if you practice long enough, is going to get an audit somewhere. It's a matter of course, be it commercial, be it government, it's going to happen. Unless you are solely taking cash only for services, you will have an audit.
That's right.
So, again, important to think about, annual audits at a minimum. Try to catch things before they happen. Try to engage people that are helping with billing or compliance that really have expertise in the field. Your cousin may be super smart, but I don't know if your cousin is the best person to be a biller.
Right.
Really think about those things and try to prevent major problems before they occur. But if they do occur, there's always ways to resolve it in a manner that's going to keep your business going and keep the status quo. It's going to be a little bump in the road in the meantime.
Perfect. Great advice. Christina, thank you again for your willingness to share your expertise and experience in this area.
Absolutely. Happy to be here and talk to everyone.
And folks, will include Christina's contact information in the show notes so that if you feel like you need her help, you can reach out to her and ask her questions. Thank you all for listening. As always, we always invite you to share with us any topics that you'd like to hear more about, or if you know a speaker who you think would be a good guest, we'd love to hear their names and consider them as future guests as well. So until next time, everyone, take care.